Let me say that I've been inundated with anticipation since I've been here, and I'm probably the only academic lawyer in this whole 400-person group, so I sort of feel like a lion being thrown to the Christians at this point. Yes. All right. Okay. Yes, I feel sort of like a lion being thrown to the Christians with regard to this matter, but in any event, one of the questions which came up this morning or yesterday was, what do you anticipate you're going to be like in 10 years' time? And I have an answer to that: I'll be dead. And then the question was, well, what's a good death? I'm not sure, but I want to be put away with the least amount of fuss. I think that would be the thing that I most want. All right. Well, let me get to law. The fundamental modern problem that legal theory brings to law and international law is the role of the human perspective in shaping and defining the possibilities of law for improving of the human prospect. And that essentially we would break up into the relevance of human subjectivity, which we break up still further into human perspective. And we would say that the human perspective, borrowing from Freud, comes with identities, demands, and expectations. And it is the complex interplay of those factors of human perspective that begin to shape the dimensions of law as we know it today. But this is a resistant idea, and in a sense, the focus on human perspectives to determine and anticipate what law might bring to humanity is essentially a vastly contested domain for the reasons that I will shortly elucidate. I want to just go back just a little, since we're in Italy. I want to basically distill three fundamental themes that function in terms of the history of law and its anticipation. And those themes are the importance of conservatism, second, the importance of progressivism, and in between progressivism and conservatism, there is the management and control and regulation of the legal myth. And the legal myth essentially means that sometimes conservatives control that myth and proclaim the virtues of conservatism while extolling progressivism, and the opposite occurs where progressives extol the virtues of conservatism and claim it as conservatism while they promote progressivism. So, in a sense, the dynamic of law is reflected between the problems of its myth as well as the problems of its operational code. That is to say, we have a law in the books, but we also have a law in action, what actually happens on the ground. And it's those tensions that reflect the evolution of perspectives about law and what we can anticipate, or the incoherence of our anticipation about law. Now, I want to just jump back very quickly to show you how deeply rooted this is historically. For example, one of the great revolutions in human history was the revolt of the Plebeians against the Partitions in Rome. And what the plebeians wanted was something conservative. They wanted a statement of the law as it is so that they wouldn't be expropriated by the dominant class. They got something called the Law of 12 Tables. Later, the Romans developed a profession of law in which the jurists, the scholars, were the dominant actors. One of the greatest of these actors was a man by the name of Ulpian, who was a Stoic and a progressive. In fact, historians, they trace the origin of human rights law to Ulpian. Well, what did Ulpian's progressivism bring him? Murder. He was murdered by the emperor because he was too progressive. So conservatism revolted against the progressivism of the great Roman jurists. Fast forward to 536 AD, the proletarian wife of Emperor Justinian, who was a bit of a dope, persuaded him to codify the law. So all that progressive law now became codified and became part of the conservative establishment. This was one of the greatest achievements in the history of the law, because the most important legal textbook ever was codified by Justinian. The practitioner's manual was codified. All the laws were codified and preserved. We would not have the law but for this preservation. But now this came essentially under the guise of conservatism, not progressivism of its original authors. Now we have to jump several centuries forward, and we come to 17th, 18th century Europe. And what we find is that lawyers are emerging with the idea that they can freeze some of these ideas of the Roman jurists and others and justify them on the basis of natural law, meaning God-given and unchangeable. And this meant that you essentially would freeze the status quo in ways that were sometimes dysfunctional. So Bentham emerged as the great revolutionary leader of the time and came up with the idea, no, you can't freeze the law. Law is made by human beings, and they should be guided by the principles of pleasure and pain. And Bentham's disciple Austin then wrote a book which still dominates our law today, and this book was a book which justified the idea of all law exclusively is the product of the sovereign. So by the time we got to the end of the 19th century, the implications of this theory of law of Austin, inspired in part by Bentham's effort to change law from nonsense on stilts, which was natural law, to human-centered law, had emerged with its own orthodoxy. And among the things represented here was the idea that there is no such thing as international law, because there is no sovereign. Indeed, there is no such thing as constitutional law, because you can't have a constitution above the sovereign. Well, a lot of sovereigns like this idea that they can be the supreme lawgiver without restraint. But this also meant that there were centuries of international law that were being thrown out of the window. And practitioners, notwithstanding the deficits of theory, practitioners began to work on ways to make international relevant to how you make war and the imperatives of peace and so on. Of course, all of this failed with the Great War of 1914. At the end of the war, two non-European statesmen, Smuts and Wilson, tried to get the international community to constrain the sovereignty idea with the League of Nations. Well, states went so far, but only so far. They would not permit the idea that you could have lawmaking outside of the sovereign. So the League of Nations could make any decisions they want, but if one sovereign said no, it was over. The League fell apart and World War II happened. And so we thought we learned something about unrestrained sovereign competence. This idea of law justifying all lawmaking in something called the sovereign. And I should say, for many, many states or sovereigns in the states, this was a very convenient idea. They don't ever want to have restraints on what they can and cannot do internationally and to their own people. So this has been the problem of our own time, of how to manage the state system, still defined as a paradigm of sovereigns interacting with each other exclusively, and the question of whether there are other forces, other principles of morality, ethics, and reason that may constrain and guide the sovereigns in ways that empower real people rather than disempower them. Now, that brings me to a technical point in the presentation, which is to do with an amazing revolt in the United States called Revolt Against Formalism. Obviously, these developments in Europe influenced the Americans. And it was Oliver Wendell Holmes who, in 1899, gave a famous speech in which he challenged the entire edifice of law as it was evolving in the Western tradition. Holmes basically had a shot at this idea of law as rules mandated by the sovereign, as implicating what you might call mechanical jurisprudence. And Holmes said, you know, this is really stupid. The best way to look at law is to look at law from the bad man's point of view. By bad man, he really meant the businessman's point of view. What does the businessman want from law? He wants anticipation. What does he anticipate? Well, he wants to know what the cost of a breach of contract is going to be. He wants to know what the cost of not pursuing litigation is going to be. In other words, the bad man pursues his own interest, and he uses law as an instrument of self-interest. Okay? Well, then the question is, where does the bad man direct his concern with anticipation? Well, it's from the legal officials that make law. So Holmes comes up with the idea that law is a prediction of what legal officials do. Prediction. Okay? And then, of course, this runs against the old conservative grain that you go back and find the law and so on. And Holmes said, oh, that's ridiculous. Logic is a misnomer. And he pointed out that as a judge on the highest court, he could give any conclusion a logical form. You don't have to look backwards. Look at the result and reason backwards, you know. That's how you solve problems. This idea of breaking down mechanical jurisprudence and the role of unthinking logic led to a revolt in the U.S. called the Revolt against Legal Formalism. And this essentially changed the focus from not sovereign making law. It does, but that's not the main issue. The real issue, the real lawmakers, are those that have the authority to interpret and specifically apply the law. So now we look at anticipation from that point of view and not from the frozen idea of the sovereign. And this notion is still one of the most contested in law in general, because conservatives hate the idea that you can pick the result and then rationalize it, versus you find the law by looking backwards. So on our Supreme Court today, we have 5 justices who insist on looking backwards to the original intent of the law, and they are called 5 goofus birds. Do you know what a goofus bird is? A goofus bird is a bird that flies backwards. It's not interested in where it's going, it's only interested in where it has been. You see. And 4 are forward-looking. So that's more or less where this debate is today, at least in the context of the Supreme Court of the United States. Now, I want to take those thoughts a step further, because we now want to just shift the focus a bit to anticipation and the state and the sovereign. And in a nutshell, the state, of course, wants to know what it costs to run the state. So it needs to anticipate tax revenues. It wants to know what resources are available to secure the state. So it wants an estimate of the resources for military services. It wants to have an estimate of its food supplies in the future, so it knows how to feed the population. And so the nature of the state itself requires some anticipation in any event, regardless of the specific components of it. And to take that still further through Holmes's analysis of the question of prediction, the idea of predicting what legal officials do means that we essentially have to look at the perspectives of the officials themselves. Where were they educated? What's their race, sex, religion? What factors would have influenced their actual behavior independently of the specific law on the books that they might want to utilize? And so this became a part of what's called the American legal realist revolution, and it still has permeated in an indirect sense much of Europe today through critical legal studies or a left-leaning approach to legal theory. Now, the problem with being result selective left open all of the questions of the nature of sovereignty, the nature of law, the theory required to catch up to what was actually happening in practice. And here the World Academy inspired many of its fellows to get into the serious business of taking a harder look, not only at law from the point of view of the state, but also from the point of view of the global community. And so the fellows of WAS developed intellectual tools to respond to the question of what to predict, to anticipate in the future. value clarification, understanding historical thinking, scientific thinking, predictive thinking, and creative thinking, and so on. I won't go through that, I just mentioned them. And so in the context of predictive thinking, I just mentioned one of the great hypotheses of creative thinking was the creation of the so-called garrison state, the emergence of a state dominated by the specialists in violence. And we see that today in the war on terror and so on. Now, I want to just touch on the problem of changing the paradigm of law from an international point of view, and that means that essentially we are confronted with sovereignty on the one hand, and we're confronted with the growth of international civil society on the other hand. We are confronted with the question of how we can allocate more competence, if you like, to civil society, to learned societies, and so on, and moderate the unrestrained claims to competence on the part of sovereign states. And so, in a sense, it is the community of non-sovereigns, essentially, that are the most virulent supporters of vibrant and realistic international law and a vibrant and realistic human rights law. And so, just to summarize very quickly the main issues for a new paradigm, I want to just draw your attention to the following. Clearly, we need to have a better sense of the whole question of global interdependence and interdetermination involving a multitude of actors and not only nation states. We want to make sure that our goals of public order are clear with regard to the protection of the dignity of every human being on the planet. We want to stress the importance of decision-making and not to obscure it from a global point of view. We want to get a clear scientific description of the principles of our global system of constitutional and public order. We want scientific clarity of the conditions which shape our global constitutional system. We want to assess future constructs and alternatives for an improved constitutional and public order. We want to use creativity to anticipate desired futures and avoid the bad ones. And the central problems here are going to be the problems of power and security, the problems of environmental integrity, population demographics, strengthening of institutions, particularly those that are corrupt and so on, power and democracy, wealth, respect, avoidance of racism and stuff, discrimination, well-being, enlightenment, education, skill, impact of technology on employment and so on. Affection, we've heard about that, but we have given it less emphasis. But global solidarity is based on affection. And we give too little attention to the effect of emotions on global behavior. So, and then finally, I've got rectitude, religion, of course, and aesthetics, the abuse of aesthetics to propaganda. So these are some of the main issues, and the problems are solvable. They're not unsolvable, but we obscure them, or we obfuscate them with complicated conceptions of, we don't know who's supposed to make the decisions, or you can make this decision, but it doesn't mean a damn thing, and so on. So obviously the challenges are not mysteries. We can look at them and we can solve them, and I'm hopeful that my colleagues in the World Academy will take seriously the idea of a new paradigm and reshape, in realistic terms, the responsibility for authoritative and controlling global governance. Thank you.